So I remember a few years ago, we had a conference in La Pietra, Florence, of Constitutional Court judges, and there were 5 members of the United States Supreme Court. And I remember Justice O'Connor telling me, this is so bizarre, I don't think 5 of us have ever found ourselves together in the same room other than when we were sitting on the court. I don't know how often the 2 of you find yourself together, but we are very, very grateful that we have with us the President of the European Court of Justice and the President of the European Court on Human Rights. And Gráinne de Búrca and I, for the next hour and a half or so, will engage you with some questions which we think are some interest, which we think a lot of the members of I.CON society would like us to ask. And if there's some time at the end, we might take some questions from the floor. And with no more ado, I just hand over to Gráinne to...
Thank you, and thank you to both of you, Presidents. We're very grateful to you for coming and sharing in the conversation with us here as our closing plenary event. A first question I think we wanted to ask you, which is of great interest to everyone, and that is, it touches on the relationship between the 2 courts, something you both think of all the time. And really to address that question through the judgment which was given by the European Court of Justice now a year and a half ago on the opinion on accession of the European Union to the European Convention of Human Rights. And as you both know better than any of us, this is a long-standing question, the accession of the EU to the Convention, and in that sense, the subordination of the European Union to a regional human rights system of control since the 1970s. And you'll also know that the judgment came as a shock to the, certainly to the academic community, but also to others, I think, in the interested in the question of EU accession to the ECHR. And so we wanted to ask you a little about that. A year and a half has passed now. There's been time for reflection, reaction. You've seen some of the responses in the literature. So perhaps we'll start with President Raimondi, and just to ask you to take us back to that time. What was the reaction in the Strasbourg court to the judgment of the Court of Justice on Opinion 213?
Thank you very much, Professor de Búrca, and allow me first to thank you very much and Professor Weiler for inviting me to this interview. It's a sign of consideration for the European Court of Human Rights. I appreciate very much. Now, on the question you asked, which was the reaction? Well, of course, the first epidemic reaction was a reaction of disappointment, because everybody knows that there is a high expectation in our court about the accession of the Union to the European Convention on Human Rights, especially after the decision, political decision to do that has been taken at the highest level, namely the level of the Treaty of Lisbon, which entered into force, of course, in December 2009. But having said that, the reaction, the more important reaction was, okay, now we have to continue to work with the Luxembourg Court in order to provide to the people in Europe and also outside Europe, people who are subject to the jurisdiction of European states, a sufficient level of protection of human rights. This is our mission, and I understand that President Lenaerts will agree with me that the Luxembourg Court is an extremely important partner in that mission. So, you know that when the accession looked imminent in early 2011, the presidents of the 2 courts, then President Costa and President Skouris, issued a common declaration stating that looking forward to the accession, the 2 courts should endeavor to produce harmonious jurisprudence. And this was conceived for the short term. But I understand that for the longer term, for the medium term, or for the longer term, the spirit of that declaration is still valid. And this has been confirmed, because we, after my election and President Lenaerts' elections as presidents of our respective courts, we immediately decided to resume the regular meetings of the two courts, and we actually met in Luxembourg last March, and 7 March, and it was an extremely fruitful and successful meeting. So this is my current thinking. Our concern is to protect human rights. And I understand, and the common feeling at the court is that the Luxembourg court is a fundamental partner and a very efficient and reliable one, as it is shown by our jurisprudence Bosphorus, for instance, which is very well known. But I have to say that this spirit of convergence towards harmonious jurisprudence is definitely confirmed by the series of judgments of the two courts in the recent years and even months. Of course, I would refer to the NS and to Aragnosi judgments and of the Luxembourg court, and from our side I would refer to the Avotins versus Latvia judgment, a very recent judgment which I understand has been very well received in Luxembourg. President Lenaerts will confirm that, which means that we are really working in that direction, which is extremely fruitful, because of course one might remain a supporter of the accession. I am a supporter of the accession. I understand also President Lenaerts is not against accession, because that would fill any possible legal gap. But meanwhile, we don't know how long this will take. The ball is definitely in the political field. We don't know how long this will take. But meanwhile, we are able to provide to the individuals in Europe a sufficient protection. Thank you.
Could I follow up with one further question? So that hasn't, the aftermath of the judgment hasn't led you to rethink the Bosphorus approach, the idea of giving a fairly wide margin to the Luxembourg organs when challenges are brought, indirect challenges are brought to Strasbourg, questioning acts taking place within EU jurisdiction. The idea that this is a system that has its own adequate standards of protection, and the Strasbourg court doesn't need to second guess that level of protection. Could I first ask President Raimondi maybe just to address from the Strasbourg perspective, and then we'll come to President Lenaerts. Thank you.
This is a well-known criticism that, in a sense, Bosphorus provides the Union with too wide a margin, and there is some risk. Well, we believe, we qualified a little bit Bosphorus with Michaud in 2012. And so we made it clear that in order to the Bosphorus presumption to be applied, we need that the full display of the EU mechanism for the protection of human rights has really functioned, including the intervention of the Luxembourg court. Having said that, we totally trust the Luxembourg court. The Luxembourg court may not be a human rights court. Sometimes this is a statement which is made by judges of that court, and it is absolutely correct. But it doesn't mean that the Luxembourg court does not perform well its job when protecting human rights. Our view in Strasbourg is that they perfectly do that job.
So I want to come to President Lenaerts, and if, with your permission, I want to ask 2 or 3 questions, sort of real conversation. The first one is the following. There was a nuanced difference between the opinion of the Advocate General and the decision of the court, and it might be by the nature of thing. I think the Advocate General, her tone and the way she presented, she says, there are some problems, but they can be fixed and then there can be accession, whereas at least in the style of writing the court, it was, there are these problems and it's incompatible. Is this just a question of nuance, or is there something more fundamental that the court itself is saying, that in the current structures, how we understand the European Union, there really is a fundamental incompatibility?
I think it now works, right? Thank you very much, Joseph, for this question. And I would first of all, also on my side, reiterate the thanks to both Joseph Weiler and Gráinne de Búrca for having invited me here. And in addition, in the presence of my good friend Guido Raimondi, the audience maybe ignores, but we both started out as vice presidents of our respective courts. And there was a link between the two presidents. That's now past, but there was also a link between the two vice presidents, and that link has never been threatened by whatever decisions on either side. And it now so happens that we are both president, and that makes indeed the contact almost natural, whatever decisions taken on either side. Now, I'll first answer specifically to the question of Joseph Weiler, but then with permission, I would also like to react to some of what has been said, but it's all linked by President Raimondi. It is true that the Advocate General has said the agreement is compatible provided the following things are being taken care of. The court says it is incompatible unless the following things are being remedied. Of course, in the tenor, and that's largely a matter of drafting style, we just say it is incompatible. But the important paragraph, and I say this also for the audience of the opinion 2/13, is the very last paragraph, where the court summarizes, almost as a mnemotechnic help, all what needs to be remedied in terms of making the accession agreement compatible with the basic characteristics of union law and the competences of the Court of Justice. Now, that standard of basic compatibility is laid down in in Protocol 8, annexed to the Treaty on the European Union and the Treaty on the Functioning of the European Union. Yes, it is correct. The Union must accede. And if the political will subsists, the Union will accede. But it needs to be done in the conditions spelled out in Protocol 8. And it is for the Court of Justice of the European Union, under Article 19 of the Treaty on the European Union, to uphold the law in interpreting and applying the treaties, to spell out the requirements to fulfill these conditions of Protocol number 8. That is what we did. And we have listed them, and it is true, all the things to be remedied mentioned by the Advocate General have been taken over by the court, but the court has added a few more, some of which may be more difficult to overcome than others. But again, and we can discuss it in more detail, if you were to put, let's now say the four of us, 2 days in a room, we could draft all that is needed to overcome all the obstacles. But it's a matter of political choice whether to put us in such a room or not. And I'm not now saying within our respective positions, but as individual lawyers. So it's not a matter of legal difficulty. Many of the issues can be solved, by the way, by the Union alone, but at the level of the member states, do not even need the other states to be involved. Such as, for instance, by way of example, the objection in relation to Article 344 of the TFEU, that can clearly be settled on the side of the Union alone, but we need a legal certainty. And there are other examples. But the most important thing is to carry over as message that I fully agree with all that has been said by President Raimondi. To start with the disappointment at the start. It's normal. You make an agreement, the agreement has been patronized, that was the enceinte for the negotiation by the Human Rights Directorate General of the Council of Europe. You believe in the thing you've done, then suddenly there are legal obstacles being identified, which sort of delays the whole project of coming through. You're disappointed. That's absolutely human. But of course, one should always realize that when a state accedes to the ECHR, it's very simple. It signs and it ratifies. The sheer fact that for the European Union it had been foreseen that an accession agreement needed to be negotiated is in itself already evidence of the fact that the Union is a legal person of international law, but is in another position than a random state acceding to that convention. The state signs, ratifies, and is bound. The Union needs a special arrangement which takes into account the special features of the Union, which is not a state, which is not aspiring to becoming a state, which is a common governance structure, a legal order, I prefer the expression a legal space even, within which member states deal with one another in a particular way.
If we're going to mix a little bit law and diplomacy, so everything you said is persuasive. So the negotiators got together. They, in total good faith, believed that what they came up with corresponded to Protocol 8. The legal services of Commission, Council, Parliament gave it a green light. You did your duty, as is your duty, to uphold the law as you understand it, and you said, no, they got it wrong on quite a long series of issues.
Seven issues, yeah.
In the Talmud, we argue if 7 is long or short. So now there's going to be a renegotiation. I can imagine one of the member states of the Council, which is negotiating, saying to the Union delegation, what guarantee can you give us that it will go back and they will say that what we did really complied with what they told us to do? Is it worth the effort? So the thinking is that with all the goodwill, it might not just be a delay, but somehow the momentum has been taken out. And there will remain that level of unpredictability because it would still have to go back to the court.
Yeah.
And the court would still have to pronounce. And there's not a theoretical possibility that in upholding the law, you will say they still don't get it right.
Well, all the examples of a second opinion which met a first one have led to a positive opinion. I can only say that as an historical fact. The first one known is the European Economic Area Agreement. So normally, if the the revision of the draft agreement complies with what has been set forth in the opinion, and it can, legally, technically speaking, rather easily be done. This is a matter of political will, then this will normally clear the way. What is indeed true, that is that the number of member states, but also maybe of third states, I mean, there has always been some degree of doubt about the determination for all of the member states. Remember that unanimity is required, and you could even ask, why was that needed in the Lisbon Treaty, to require unanimity for the accession agreement, if it is so that primary law of the Union obliges to accede? Then you would say, if this is a bound competence, they can in fact do it, almost with a simple majority, because it's pure implementation. But it is not. So they still see this as, the member states as her en der verträge still see this accession agreement as high politics. Therefore, unanimity is required.
Which of your condition?
They hide now behind our back and say, the court said it was not possible. No, the court did not say that the accession is not possible. On the contrary, the court says that the accession is possible when you pursue the list. So, what are the things to be done? Mutual trust and fundamental rights. That is exactly our two courts have cleared the way.
Which of the 7, in your view, is the most fundamental, the most difficult, where there will be the most delicate negotiations?
Well, the most difficult is in fact the exclusion of the CFSP, the Common Foreign and Security Policy, from the area of competence of our court. And this, if one thinks deeply, both from an ECHR and from an EU law perspective. Because if the Union is to be bound for one of its policies for which the internal remedies cannot be exhausted because there are no remedies internal to the domestic legal order of the EU for lack of jurisdiction, then the Strasbourg Court will directly have to judge these matters, but without having the benefit of a last instance court judgment, which normally the Strasbourg Court has. Because the system of the ECHR is a subsidiary system, and for good cause, because then the Strasbourg Court starts from the interpretation of national law, from the constitutionality review, which was carried out in national law, and they have all of that, and against that backdrop, they apply the convention in a concrete case. If the CFSP decisions go to the Strasbourg Court after accession without further ado, they will have to rule against a blank sheet. That is for me the biggest problem. But again, that is a problem of the member states of the European Union. It's not a Strasbourg problem in the end. The member states of the European Union will somehow have to come to terms with the fact that our court, that is the General Court and the Court of Justice, will have jurisdiction for all CFSP decisions which are fundamental rights sensitive. And I can tell you, and that is why time also does its work, it's not just a matter of focusing on this last paragraph of the opinion and the law and diplomacy question. But what we have done in the last 1.5 years, that is make our case law develop. It's sort of the homework. And our two courts are totally interconnected on that, also since the opinion. We, in our jurisprudence, show largely the way for many of these problems. I can't say much more about it, but we have now 2 cases pending, H against Council, on a decision to re-affect an Italian magistrate in Bosnia-Herzegovina, the rule of law mission, from Sarajevo to Banja Luka. And she brings a case in the General Court against the Council. That's a CFSP decision. But she says, this was moral harassment against me. So she attacks this on fundamental rights grounds. And the Council says, no jurisdiction. She says, yes, but I can't go to the Italian court because Italy has nothing to see with it. So there you see the pure gap. The General Court held that it had no jurisdiction on the basis of the CFSP exclusion. H appealed. Our judgment will come before the summer break. I can't say more. But you see, those are stepstones for the matter. The Rosneft case is another example. There's a Rosneft, one of the Russian big oil companies, coming under the sanctions regimes, attacking in a UK court. The UK court asks a preliminary ruling on the validity of a CFSP decisions on sanctions. Problem, Article 275 of the TFEU provides for actions for annulment against sanctions decisions, not for the preliminary rulings procedure to apply. Do we close the gap or not? Is this a situation of Lenaerts against European Parliament or not? That's now pending in the Grand Chamber of the Court. Those cases might help to bridge the gap. But that's why I say this is not just a matter of diplomatic negotiation after the opinion. It's a matter of our case law knowing against what backdrop legal shortcomings may have to be judicially filled. All the cases which Guido Raimondi cited, which are marvelous cases, the audience really should read them. It's the Povse case and the Avutings against Latvia case of 26th of April of this year. By the way, that contains in full wording the answer to your question, Gráinne. Yes, Bosphorus does apply. It's a decision of the Grand Chamber under your presidency of this year. Huh? So 26th of April 2016, where the Bosphorus case law of Strasbourg, as further refined and with total agreement of everyone in the Michaud case, fully applies to a Brussels I case. Huh? So it would lead me too far to explain the case. And we have then in our case law, after all these, because that's something which I say for this young academic audience, after our NS judgment, which also Guido mentioned, the NS judgment is this famous case about you can't send back an asylum seeker to Greece when there is a systemic deficiency. So that the risk exists that there will be inhuman and degrading treatment, systemic deficiency. And the Human Rights Court takes a more individual-focused approach, Tarakel against Switzerland. Then you have hundreds of pages, probably thousands of pages filled about the divergence of the two case law. That's all bogus, huh? We said systemic deficiency because the referring court said to us, there is clearly systemic deficiency. We know it because we have Strasbourg case law on that. Faced with that, should we hand over? And we said, no, if you have that problem, you don't hand over. That's how judges talk with their counterparts in the domestic courts. That's the way the question is put, and we say yes or no. Here we said no, you should not hand over. That is not to say that short of a systemic deficiency, you can do everything. This was simply not covered in that case. If you take now the more recent Aragnosi and Caldararu cases, those are really fantastic cases, 5th of April 2016 of our court, in relation to the European arrest warrant, where we fully take over and quote the Strasbourg case law, that you have to focus on the individual case of a person asked to be surrendered from the executing member state to the issuing member state under the framework decision relating to the European arrest warrant. And we say the issuing member state judicial authority should give all the assurances sufficient to convince the executing judicial authority that that specific person will not be subjected to inhuman or degrading treatment contrary to Article 4 of the Charter, which is an inviolable, unqualifiable fundamental right. So all those who have said mutual trust is more important than fundamental rights protection, they know better, as Daniel Halberstam wrote on Verfassungsblock. I saw that one of the contributions, read his contribution, and he exactly got it right. But cases develop like this. So if you take our Aragnosi Caldararu and their Avutins versus Latvia, both cases of April 2016, there you see the solution to the balancing of mutual trust and fundamental rights is in those judgments. Huh? You simply have to codify what is in both their case law and our case law. Again, if the political will is there, it's so easy.
Koen, can I ask a brief follow-up question, then less a judicial one and standing back a little? From what you describe, it sounds as though you're both very happy with the relationship, but the way in which you mutually observe one another. Do you think it almost sounds as though accession is redundant, you know, that accession wouldn't add anything to the mutual observation? No. Do you agree?
Well, I agree with what you just said towards the end, but I disagree with the undertone of what you ask. And that is, you say, for the good cooperation, accession is not needed. That's correct. That's the part I agree with. It's clear that we read one another's judgment. Do not forget, we are a general Supreme Court for the European Union. Our first task is to guarantee, like we said in Aukerberg, Fransen and in Meloni, the primacy, uniformity and effectiveness of union law. And you know why that is so? It's simply putting into effect the equality of member states before union law. People always now decry primacy and they say, well, primacy should be balanced against national constitutional identity or national identity. But what we are speaking of is the level playing field. If someone claims one Zonderweg, then of course all the 27 others can claim that as well. So we are sticking to unity, primacy, effectiveness in order to ensure equality of all the member states and their citizens before union law. That's our core task. If in the process of doing so, we come into a fundamental rights problem, which happens for the Court of Justice, the upper court, in no more than 10% of our cases. Those are the ones we discuss here, and that's fair enough. But, I mean, you should see the picture globally. So let's say 60, 70 cases a year, mostly before the Grand Chamber. Not always. Grand Chamber or Chamber of Five with an opinion of an Advocate General. So these 10% of cases, where go we look? We don't reinvent the wheel. We watch first the case law of Strasbourg. That's our primary source. Article 52, third paragraph says it of the Charter, the corresponding rights clause. We may never protect less than they do, but the story doesn't end there. We read the Constitutional Court case law and the Supreme Court case law. Of the 28 member states, there are 18 with a Constitutional Court. There are 10 without a separate Constitutional Court, but the Constitutional Court function is taken up by the General Supreme Court. We read all that case law. You will say how you read, I mean, language barriers. No, not at the court.
No, President Leonard, we really don't call into question the thoroughness of what you do and that you look at the jurisprudence of the European Court of Human Rights, at the Constitution and case law of the member states, at the Charter of the Union, etc. Yeah. And the bottom line is, I go back to Gráinne's question. So having done all that, do you at the end of the day say that accession would be redundant?
No, absolutely not. So that was the part with which I did not agree. I still had to come to it. So we do not need accession for the dialogue, and that's exactly also what Guido Raimondi said. We have good meetings, regular meetings once a year organized, but in many occasions like this one, informally. In November, I'm even 2 times in Strasbourg for the Sechsertreffen and later the month for the tripartite conference on asylum. So we meet all the time and we read all the time. However, accession is necessary, not because of all of that, but simply because the European Union is a domestic legal order, domestic to the European Union. And I say for the Germans in the room, domestic does not mean state-like. Because often they think that when I say domestic, I simply mean the European Union as a self-referential legal order whose ultimate rule of recognition, to speak with HLA Hart, are the treaties on the European Union, on the functioning of the European Union, and the Charter of Fundamental Rights. That is our ultimate constitutional standard, but which is rooted in the common constitutional traditions of the member states in the ECHR. So the external review is always a plus, like it is for the states. And that message has maybe been sort of, how do you say that, occulté. It has somehow been concealed maybe to some because they said, we had so much hope that we got through this. And I understand the disappointment, but if you make a fresh reading of the opinion, you will see that the court says very clearly that accession is the goal to be achieved. But it must be achieved under conditions which make the European Union, which is an extremely peculiar animal in the legal landscape. Remember all these big discussions, whether it's a federalism system or a special international organization. I mean, in theory, all of this is very interesting, but in actual practice, you have to decode all the essentials of that system in order to make sure that accession would not make fall this legal order, which is a very delicate legal order. It's united in diversity. It sounds well as a slogan, and I'm very much sticking to it. It's ordering pluralism, to say it with the Mireille Delmas-Marty, ordering pluralism. It's fantastic. That's the true added value of the Union. But to do that in a system and have that system accede, it must be done, but it's a difficult, technically speaking, a difficult operation. But our case law bodes well, both in Strasbourg and in Luxembourg, to show the way. So it will be done.
If I may, I have really little to add to what President Lenaerts said. Of course, from my side, the reply is obvious. I don't believe that accession is redundant. Of course not. President Lenaerts already mentioned one reason, which is an extremely important one, which is the need of an external control. And this is more a political need. In fact, accession will respond to both political and legal needs. From the political side, of course, I have nothing to do on that. It is not, I'm not entitled to say anything on that from that point of view. From the legal point of view, there is the possibility of a conflict between the two case law, if there is no. This is obvious. This is why, from a legal point of view, the idea of the accession is not really redundant. Absolutely not. Having said that, and I completely agree with President Lenaerts, we have to, even if the accession is not for tomorrow, we have to work together in order to fill all the gaps. And President Lenaerts mentioned the magic word, or the magic figure, which is 52.3, so which means that provision of the Charter on Fundamental Rights, which is the bridge between the European Convention on Human Rights and on the one hand, and the European Charter on the other hand. And so if, and this is clearly the intention of the Luxembourg Court to fully apply Article 52, paragraph 3, okay, so the gap will really be minimized.
Thank you. I think we should move to a next set of questions. That was a very illuminating discussion. But one of the features, I think one of the distinctions between the two courts, the differences between them, although they exercise some overlapping, some similar functions, they're very different kinds of courts, but also in their style and modus operandi. And the Strasbourg court comes across as a more transparent court. You have amicus briefs, you're more open in your, you have televised proceedings for some of the hearings, you have dissenting opinions. There are many features of the judgments that are rather different from the Luxembourg style, which is influenced more by the, it's a more sealed kind of process. The kind of reading that Koen mentioned that happens, reading the judgments of constitutional courts and so on, the external viewer doesn't see that. It's very evident in the Strasbourg rulings. It's not so evident in the Luxembourg rulings. So their styles and procedures are rather different. And so we're interested in some ways in how that reflects on the court itself, in both whether that's an advantage, whether it somehow strengthens the position of the court or can sometimes be a difficulty for the court. So can we start with the issue of dissenting opinions, which is a very familiar one, which is one that has arisen over the years, where the Strasbourg court did move very early on to dissents, but the Luxembourg court has not.
Thank you very much, Professor. Yes, you know, when I arrived in Strasbourg 6 years ago, well, you know, I come from a legal culture which does not recognize separate opinions. So in the Italian legal system, judgments are adopted in secret, and nobody knows what happened during the deliberations. Only at the constitutional court level you might guess, because if you have in that connection, you have the rapporteur who is mentioned, and you also the drafter who is mentioned, and normally the two positions coincide. When they do not coincide, you have some, of course, you can make some guess on what happened during the deliberation, but that's more or less all. So I came to Strasbourg with not really with a favorable attitude vis-à-vis separate opinions. Then I have to say that I changed my mind, in the sense that separate opinions can really help the development of the case law. The dissenting opinion of today can be the case law of tomorrow. And this actually happened in a number of instances. So you might have a more progressive judge, excuse me, we don't use justice in our court, we are all simple judges. might be more progressive, and maybe some may say something which looks revolutionary at that time, but it becomes normal 20 years later. So this is why I'm convinced that separate opinions, not only dissenting but also concurring opinions, play an important and positive role. Of course, judges filing a separate opinion should be extremely careful not to be aggressive vis-à-vis the reasoning of the majority. They should remain respectful, and this is an ethical issue, which is in a way also my responsibility as a president to monitor, and I take care of that. And apart from that, yes, it is true that with the perspective of the entering into force of Protocol 16 to the Convention, maybe we'll address this point later during our conversation, which is a very interesting point. But from the perspective of separate opinions, you know that the protocol will allow separate opinions. And this might create difficult situations, because if you have, you know that in that connection, national superior courts which will be allowed to request advisory opinions from our court will not be obliged to do so, unlike what happens in the parallel EU system. And when the court will not be obliged to deliver the opinion, but even if in case of rejection, the court has to explain why the rejection takes place. But when the court delivers its opinion, the opinion will not be binding for the national court. And you can imagine an advisory opinion adopted with the majority of 9 to 8, with 8 strong dissenting opinions. So in that case, I see really a problem. But I hope that this catastrophic scenario will not occur. We are not even in the moment when the protocol has entered into force. I hope this catastrophic scenario will not occur. But apart from that, I have to say that my global assessment of separate opinions is positive.
Could I just follow up very briefly? I'm very interested in what you said about separate dissenting opinions and the tone and so on. There have been some famous Strasbourg dissenting opinions which are sharp in tone. Is that something that can be controlled within the court? Presumably judges have a degree of freedom in what they say.
Of course, the president might only have a sort of moral suasion, of course, not more than that, because of course it goes without saying that even, and you know, the convention is clear, the judge has the right to file a separate opinion, to attach a separate opinion to the judgment. So, but of course, the president has a certain responsibility for the image of the court, and so it has some right to address informally the colleague when there is an issue, but nothing more than that, of course.
Can I just footnote as a preparation to President Lenaerts taking over? One of the advantages that is often discussed of separate opinions, for example, in the practice of the Supreme Court of the United States, it's that the existence of the separate opinion which is circulated improves the quality of the majority opinion, because they have to address certain issue, and it improves its communicative quality, that without the separate opinion it might be more bland, etc. So with that in mind, let's hear President Lenaerts on what's your take on the advisability of separate opinion in decisions of the ECJ.
Thank you, Joseph. Well, I would like to start where President Raimondi has come to in relation to Protocol number 16 and the advisory opinions which might be given in that context. Because, as he said, very rightly so, that comes similar to the references for preliminary rulings on all aspects of European Union law, not just on fundamental rights. And there, the member states, as her der verträge again, have in the primary law rules of the Union provided that the judgments must be adopted in a collegiate fashion and under conditions of secrecy of deliberations. So, Joseph Weiler rightly asks, what is your personal take on advisability, that is whether to change or not, and I'll immediately come to that. But just that the audience not be confused, the discussion here is wholly academic, because even if our court were tomorrow to say we needed dissenting opinions, we can't. This is primary law. You need a change of the rules. So let's not forget that. Now, the reason why the member states als her en der vertregen...
A footnote too, because the WTO rules also have a similar provision, but they have found a way. So there have been famous decisions of the WTO that in the unanimous decision, they still indicate that there was a difference of opinion. And actually it helps.
Well, this may be for the WTO, I'm aware of this practice, but in the European Union law as a system, the court is of course extremely mindful of complying, because these rules have been stated in the court statute, which has the level of a protocol equal to the treaties, and then has been confirmed in the rules of procedure, which have also, as you know, been approved by the Council. So be that as it may, I take the point, but it's... Now, I said I connected to what Guido Raimondi said in relation to that Protocol 16 and the preliminary reference procedure. I think the member states have come to the view that the role of the preliminary reference procedure ever since Van Gent and Loos is precisely, as I already said earlier on, to guarantee the equality of member states before union law. Direct effect, primacy, national court enforcement of union law, preliminary reference. They are all angles of the same reality. That is that the union law should be interpreted uniformly and enforced uniformly in all of the member states. They have therefore made the bet, and it's a bet, it's as good as it goes, that by solidarizing all of the judges coming from, all of them from other legal systems, to have an input in the decision-making process, it will increase the chances that the end outcome is at least, you'll say it's a minimal ambition, at least not shocking in terms of legal stuff, not shocking to any of the national legal orders, because all of these preliminary rulings, that's also why they are translated in all 24 official languages, they are the law of the land in all 28 member states. And in order to have compliance with that sort of glossary, which through the preliminary rulings is made on our case law, on union law, on written union law, I mean, they wanted to have a very, very strong uniformity and adhesion everywhere. That's the formal justification for this collegiate way of going. You should know from the 700 cases decided by the Court of Justice, the upper court, 2/3 are references for preliminary rulings. So that's clearly what they had in mind. Now, I absolutely agree with what Joseph suggested, that when you have a dissent, this might improve the reasoning of or strengthen the reasoning of the majority. Now, as a president, I'm presiding the Grand Chamber of the Court of Justice. The Grand Chamber decides the 10% leading cases a year. I'm always saying before American audiences, the cases in which the United States Supreme Court grants certiorari, about 70, 80 a year, are the cases which we send about the equal number to the Grand Chamber of the Court. In all areas of union law, they're the lead cases. There it's a task of the President to get 15 judges stemming from all different legal backgrounds, professional backgrounds, cultural backgrounds, linguistic backgrounds, to get them on a coherent line. And I can tell you that this process is taking place in writing and orally. In writing, you get the full range of adversity of views. And if in the end a majority view emerges, almost on the basis of deliberative democracy in our gremium, where we empathically listen to the others, try to integrate strong points of several arguments in a consistent line, because we have in the end to convince with a single reasoning, it makes that those who hold a particular line, faced with objections by others in the deliberation process, they will do the sharpening of the line there. At the same time, they will also take into account what this minority has as a real concern. And you may say, oh, but that leads then to sort of, a grayer judgment, a judgment which is less outspoken. And I understand fully that I'm also an academic, that this is sometimes frustrating, also for me, when I read in my other capacity some texts. However, in terms of making union law work, an integrative approach, which goes step by step, might be superior in terms of consolidating the law of the Union to these high-pitched debates, which are maybe more proper to a national context. Now, the distinction between our two courts should also be highlighted. Those are totally different courts with totally different functions. And they're both necessary. That's why I said that accession is not redundant. The Human Rights Court is a court, Protocol 16 is not yet into force, which deals with what we call in the jargon direct action. It's an applicant against the state. And it's a case, an individual specific case, for which that court has the whole file. The facts, the national law context, all the decisions taken, exhaustion of the local remedies, the system is subsidiary, and you reason also in the narrative of the judgment all of that in. Then you have the national judge requirement, not in the Court of Justice. We don't have a national judge requirement. And after the enlargements of the year 2000, this really works that way. Because until 2004, don't be mistaken, there was no national judge requirement, but all important cases went before the full court, which was 15 judges. That is all the member states. But since 2004, we do not have the national judge. Can you imagine that when the national judge is sitting, it's often the national judge dissenting, read the Strasbourg record, that you have when the national judge is sitting, he would be dissenting. If he is not sitting, the member state would have the impression he is not there. Because sometimes he will be sitting, sometimes not. Gesetzliche Richter, it's a totally neutral system. So all these elements come in, and that is what you should, I think, bear in mind. Our core business is preliminary references. Their Protocol 16, where they doubt as well for the dissenting opinions. Their core business, the only one so far, is direct actions in individual cases. And we can't say too much about the facts of the case, because if we did, we were stepping into the realm of the national court. We have to say the European Union law, but we can't really get down into the arena, which makes necessarily the style of the judgment a bit more abstract. With all of that said, it is one of my main priorities to strengthen the drafting quality, especially of the Grand Chamber judgments, to be far more explanatory. You have seen we quote far more extensively this last year already the Strasbourg case law. Not national case law, because there we would get the criticism that we can't quote the national case law of all 28 member states, because we don't have possibly an equal access. So we look at it, but we can't really use it. To say selectively we use a German case or we use an Italian case, the one big jurisdictions we can follow very easily, the languages which we know, but why not the Estonian, the Greek or the Cypriot one? And so that's a matter of, it's always this idea of equality of member states before union law. But the explanatory quality of our judgments is to increase, and the way we do it is to quote the human rights case law when that is relevant, but also to distinguish the present case from all sort of neighboring cases, cases decided earlier on, to explain in a fairly narrative style now, even if it's still formatted in paragraphs, why the case we now decide is analogous or just not analogous, and why we do follow this case and not that other case, so it's more didactical.
Can I say something to that? Not to harp on the dissenting opinion. It's not going to happen anytime soon,
No,
etc. And I think everybody in the interpretative community of European Union law will welcome this priority you're giving to the quality of writing the judgment, its communicativeness, its explanatory. But from what you said, if I understood it correctly, you said, look, it's a delicate situation, we get a preliminary reference, we have to issue a preliminary ruling, we want to issue it with the strongest possible compliance pull. And for example, if we had a dissenting opinion, especially if it was a dissenting opinion from the national judge, it will weaken the compliance pull. I want to sow an idea, seed of an idea in your mind, which I think all institutions of the European Union have to do now, given this kind of the populist rise and Euroscepticism, which is no longer epiphenomenal, but really quite becoming more and more mainstream. And maybe the way is not simply to pile on all the arguments that justify the judgment and say, and look, it's unanimous and we're all onto it. One wants to see the dissenting voices, that at least they were there, they were heard. And the feeling is that it might be this kind of 1, 2, 3, 4, 5, and look, there has to be a feel, and that's what often the dissenting opinion provides, but there might be other techniques to provide to it, that the minority view, that the dissenting view is seen to have been articulated, and that it is given a voice. And at least so far, that is very rarely the case in the jurisprudence of the court, and if it is the case, and I have many examples in my mind, it's dismissed very curtly, which suggests it's not even taken seriously. So I think with the same purpose in mind, you can improve compliance pull and legitimacy by actually acknowledging dissenting and separate points of view.
And I also wonder, just to add to that, whether the experience of the Strasbourg court, I completely agree there are very different courts in the way they function, but Strasbourg has a compliance concern also, and I wonder whether there's any empirical evidence for the proposition that dissents, sharp dissents or dissents from domestic judges affect compliance. I mean, it might be an interesting project for someone out there to engage in, but it's a question. That's really what we're saying, whether the concern for compliance, which seems to be your main argument for not having these kinds of, for the style of judgments and for not having dissents appearing, is it may be worth asking whether that really is based in fact.
Well, that's the main argument why the member states have decided not to have them. So what I've done here is especially decoding their reasons to so steadfastly not wanting them. And the European Parliament has sometimes, that in resolutions called for them, and the Council has always said, no passerán. So it has been on the table for the Lisbon Treaty, for instance. The Parliament had called for that, European Parliament. The Council said, no passerán. So that's why I'm saying that must be the reason. But I find what Joseph says very important, the making visible of the different possible tendencies. Now, you will say, this is maybe a very weak second best. But we have in all our ground chamber cases and in all cases of chambers of 5 decided with the benefit of an opinion of Advocate General, which we can now, as you know, sometimes have, sometimes we don't have it. That means all the most important cases. We have hearings. The hearings are now a very interactive process. This is, by the way, the input of the General Court. Many of the judges in our court, including myself, we were educated to being a judge in the General Court. And the General Court has very interactive hearings. So we took that with us in the upper court. So you have rather lengthy hearings with full debates, much longer than in the US Supreme Court, by the way. It's sort of full discussions, and judges are really testing their opinions and all the plurality of approaches. And that is happening in the biggest openness. And yes, indeed, also in Luxembourg, we are studying to stream our hearings. Maybe not all of them, because there are also some parties against it in commercial secrets cases or in many cases. But if the parties agree, we could also stream to make the process very, very transparent on that score. But in the actual deliberation, you will not believe this, but I think that I'm not transgressing my oath of office, which calls for secrecy of deliberations, when I say in general, in our cases, there is no vote. When we have to vote, even in the Grand Chamber, this is felt to be a failure. So we are confronted with a plurality of views, sometimes always triggered by the opinion of the Advocate General. The judge rapporteur, reporting judge, reacts to the opinion of the Advocate General, and all the other judges start giving their view with a short explanation. Then the President calls an oral deliberation, tour de table, and we have a general discussion, which in difficult cases might last over 2 hours for a single case. And we check all the arguments, and we try to find a way which accommodates what initially started out as opposing arguments. And we come to a view which is then also rooted sometimes in, as I said, neighboring parcels of legal orders. If you want an example, the Digital Rights Ireland case, which is a crucial case where the court quashed a directive on data retention, and we were greatly helped by the S. and Marper versus United Kingdom case of a few months earlier of the Human Rights Court, which we quoted extensively, and it helped us out. So what I mean to say, just as that's on public record, because you can read Digital Rights Ireland. So we try to converge, and that's the way it goes. For the Belgians in the room, I see there are a few of them, they know that it is exactly the same in the Belgian Constitutional Court, where you have 6 Flemish and 6 Francophones. And if there is a very sensitive Flemish-Walloon issue, the court sits with all these judges together and they don't vote. And the presidents tell me, because there are 2 presidents, a Flemish one and a Francophone one, they say the day that we have to vote, Belgium is over.
Can we bring in President Raimondi?
That's also for the European Union the case.
Thank you. I
know that time is running out, but just a quick word on this issue, because sometimes we read in some judgments of national constitutional courts, oh, this judgment of the Strasbourg court has 1 or more dissenting opinions, so we can take it lightly because it is not really case law. This is simply legally incorrect, because if I refer to Article 19 and Article 32 of the Convention, every judgment of the court has the authority of res interpretata. I don't refer to Article 46, which speaks about authority of res judicata, but this concerns only the parties to the case. But even for the parties which are not parties to the case, there is the authority of res interpretata, whether there are separate opinions or not.
I want to say something.
That tells it all on compliance, by the way. There's
maybe a philosophical difference. I am suspicious of unanimous decisions. the Sanhedrin rules say that any decision that unanimous is invalid because it's suspicious that all the judges agree. That's just teasing. I want to go to a delicate issue, which is the caseload, because in both your courts, I have several students sitting on both courts, and they say this is hard work. There are an awful lot of cases. Now, for years, I think, with all respect, the main concern was managing the flow because of the time issue. Justice delayed is not justice. But there are other aspects to it. The time to think, the time to deliberate, really the time to craft a good communicative judgment. So how do both of you relate to this issue of a very heavy caseload, and yet the need to issue not only decisions on time, but well-deliberated, well-crafted, well-thought-out decisions? Maybe we start with you, President Raimondi.
Thank you very much, Professor. Well, indeed, caseload is really, I would say, my main concern, my main challenge as the President of the Strasbourg Court. Now the figures are concerning. But I would say that because we had dramatic improvement, because 4 years ago, figures were not only concerning but scaring, because at the end of 2012, we had 160,000 applications pending, which was really scaring. Now the situation improved. We have now around 69,000 applications pending. Why? Because meanwhile we had the effect of the entering into force of Protocol 14 and the designing and the implementation of new working methods related to the new judicial figure created by the Protocol 14, namely the single judge. So through the single judge we were able to dispose of efficiently of all cases which are manifestly inadmissible. So now the backlog of manifestly inadmissible cases is under control. I quoted this figure of 69,000. Within this 69,000, there are roughly 3,000 to 4,000 cases which are manifestly ill-found. This is the physiological backlog, so this is absolutely not concerning. And what we can call manifestly ill-founded cases represent more or less 95% of the cases. But unfortunately, the figures remain concerning. Why? Because around more than 60,000 of cases are cases which are not manifestly ill-founded. Half of these cases are of a repetitive nature. And these cases are less concerning from my point of view. Why? They, in a way, weigh less on the conscience of the court. Why? Because repetitive cases normally represent difficulties in the implementation of jurisprudence of the court, which is already well established. The most well-known example concerns my country. The court identified almost 40 years ago the problem of the excessive length of proceedings, judicial proceedings in Italy. Italy has not yet resolved satisfactorily this problem, so cases continue to reach the court. These are a part of our backlog of repetitive cases. So these cases, as I said, do not really concern me, on the one hand, because the court has already done its job in a way, it's already said whatever it had to say in terms of jurisprudence. And from the other hand, we are able now, we have developed IT tools which allow us to deal efficiently with these cases. We can get rid of these cases in 2 or 3, maximum 3 years. So, but unfortunately, there are 30,000 cases which remain, which represent what we call cases which are not manifestly ill-founded, and there is a quota of these cases which are of a priority nature. You know, the court in 2009 adopted a policy on a prioritization of cases. So there are cases which are more urgent than other cases. And these cases are concern the most obvious breaches of the convention. I refer, of course, to Article 2, right to life, Article 3, prohibition of torture and punishments of treatment contrary human degrading, Article 5, deprivation of liberty, Article 4, forced labor, and so on and so forth. All concern vulnerable persons, children, for instance, and systemic problems. So roughly 12,000 of cases are of a priority nature. But apart from these cases, which more or less we can address with some efficiency, I would not say totally efficiently, but with some efficiency, the rest of the cases are normal, what we call normal chamber cases, and which concern important issues like freedom of expression, freedom of association, fair trial. These are important issues, but unfortunately we are not able to deal with these cases efficiently. These are not priority cases. And this is a real problem for the court. Having said that, I come to your question. Of course, the quality of the judgments remain a primary, a fundamental, a paramount concern for the court. It's, of course, without well-reasoned, well-drafted judgments, the authority of the court will not be simply there. So this is, of course, we cannot compromise on the quality of judgment, especially when it comes to the judgments of the Grand Chamber, which represent, of course, the most important cases and which are normally the cases to which scholars and students refer to. And unfortunately, this is time consuming. Now we have started a reflection in order to try to simplify the judgment, at least the chamber judgments, to the extent possible. Now, you know, the style of our judgments is consistent, I would say, and the judgments have all the same structure. There is a section on procedure, a section on the facts, there is a section of national law, a section on relevant international materials, then there is the law. And in the law, we address separately all the issues, all the complaints, and for each complaint there is an analysis on admissibility and an analysis on the merits, and for each point we expose the general principles, and then we apply the general principles to the case for each single point. We make an effort to be clear. So one might say that our judgments are boring, but they are clear. So there is a clear effort to make them readable by everybody. And this is, I understand, this is the case. But having said that, we are able to produce roughly 2,500 among judgments and reasoned decisions. And with this pace, how can we get rid of these 30,000 and more applications? So this is the big challenge, the big concern. And the reply is, of course, we can continue to design and implement new working methods. We are doing that. Now we have developed, and we are trying it on an experimental basis, a new form of communication. So, you know, the communication is an important moment in our procedure, and so far the communication was accompanied by the detailed document on the statement of facts prepared by the court. Now we ask the states to prepare that document, which of course will speed up sizably the procedure. We can do that. We will continue to develop new working methods. But this, at the end of the day, will not be sufficient. So where is the reply? The reply is in the better functioning of subsidiarity. This now is absolutely clear. So this has been said emphatically by the Brussels conference last year, in March last year, which launched the slogan of shared responsibility. So the system will not work if national systems do not improve. So the most important actor in the framework of the European system for the protection of human rights is not the Strasbourg Court, it's the national judge. So, and unfortunately now we have cases in which this does not concern all the contracting states. We have contracting states which have a very little modest record. If I can mention one, is the United Kingdom, which has a very modest record of cases before the court. There are other states, unfortunately, including my own country, which are in another position. There is the famous top 5 of high count states, which contribute a lot to our work. But if the caseload of concerning these 5 top 5 would not be there, the court would function regularly. So I hope that I provided some elements in response to your query, Professor.
Absolutely. Koen, caseload, burden on judges, who should do preliminary references?
Thank you, Joseph. First of all, I fully agree with your suggestion that, of course, justice delayed is justice denied. But this may not go at a price of not having the time to produce quality. In that respect, I fully agree with President Raimondi. I always say, before many audiences where I go, justice delayed is justice denied, but justice in haste is also justice denied. And it's the big challenge for any court, including my own, and there I bear as president the primary responsibility, to find the right middle between justice delayed and justice in haste. Now, here again plays the important difference between our two courts, in that the core business of our court is to answer references for preliminary rulings sent to us by national courts. Here as well, national courts should do their part of the work. So it's not subsidiarity, but it's the very fundamental idea underneath is the same one. In the system of preliminary references, that is what we spelled out expressly in the revised rules of procedure in Article 94 of the Rules of Procedure of the Court. 9.4. That's the crucial provision, you find it on the website of the Court, where we spell out all what the national courts need to have done when they refer to us. Establish the facts, establish the national legal framework, settle all procedural issues, explain precisely the reasons why they think union law might be relevant to the outcome of the case. Because a preliminary ruling is not an advisory opinion. It's a true judicial decision contributive to the outcome of the case pending in the national court. And we even encourage the national court to pre-reason itself the solution of union law and to submit it to us for certiorari, in fact, to make more certain. With the consequence that a pan-European debate which is triggered with that order for reference will take place against the backdrop of what the national court has pre-reasoned. Now, for preliminary references, we need to be short in terms of time because it's a parenthesis in the national proceedings. And we do not want to become co-guilty of a transgression of reasonable time in the national proceedings, reviewable in Strasbourg, and rightly so, because we were too late with with replying to the reference. And I'm proud to say that when I came in the upper court, I made my transition from the general court to the upper court in 2003, the average of a preliminary ruling procedure, the average was 29 months. Now it's 14 and a half. So it's cut in two. We have become much more efficient in our translation process because we work in 24 languages, as you know. It must all be translated inside. All the member states can come in with observations in their own language. So the language factor is enormous. So we had the ICT developments in the translation services allowed us to cut down enormously. So we're much more efficient. Internally in the court, everything is done in a digitalized way, in a non-paper file. So it goes very, very far. So we have made enormous gains of productivity. Now for cases which need to be even quicker than this 14 months average, which means that it is in many of the preliminary references shorter anyway, when there are few member states manifesting themselves to intervene in the debate, but some need to be really very short. That is when the person in the main action is being detained, deprived from liberty, either in a criminal law context, European arrest warrant, or in the asylum and refugee context, or a Brussels 2 bis context, parental authority for children. There are also not really detention, but very urgent matters. There we have the famous PPU, which we now have for slightly over 8 years. It's the urgent preliminary procedure, where we decide a case on the merits. So that is not an interim relief, it's a definitive pronouncement of our court, and this within 3 months as a maximum. The famous Caldararu case of the 5th of April of this year, which has been joined to Aragnosi, that Caldararu case is a PPU case. Grand Chamber, groundbreaking judgment, handed down in 3 months on the balancing between mutual trust and fundamental rights protection. So you see, we have the tools of working very quick when it's needed. Now, this is only possible when the court makes a very good judicial management and discriminates between the very important cases and the routine cases. And that's the task of the general meeting of the court. Every Tuesday afternoon, all the judges, all the advocate generals and the registrar assemble under my presidency, and that is the big dispatching meeting where cases are assigned to the several benches for final decision, with or without an opinion of an advocate general. That process really needs to get it right. That is, that the important cases go to the Grand Chamber or to a Chamber of 5 with an opinion of Advocate General, invariably with a hearing, that the less important go to 5-judge chamber without an Advocate General, or to 3-judge chamber and be disposed of by simple order. By making those decisions rightly with a view to the importance of the case for the general development of union law, and possible other aspects of importance in the case, we are capable of managing the process correctly. So if a reference for a preliminary ruling comes in, or also an appeal against the judgment of the General Court, which is clearly unfounded or even inadmissible, we throw all that out with orders within a matter of months only. Months, so that's cleared out. Then we focus on what's really worth it, but within short time. Now, that is for the court, the Court of Justice. The institution, however, Court of Justice of the European Union, comprises, next to the Court of Justice, the Supreme Court, also the lower court, the First Instance Court, now called General Court. They have a little bit the problem of the Human Rights Court, all measures taken. It's not those figures, but the General Court is a direct action court. I already made that distinction between direct action and preliminary reference. When you have preliminary references, you have always national courts which must make the assessment, is it worthy to refer? And these national colleagues are highly esteemed judges, and we work very trustfully with them. They make a good selection. They only let through what they really cannot find on your legs and their own way. And, you know, that's a good filterage system. But for the direct actions, everyone tries his or her chance directly in the European Union bench. So the upward pressure for cases brought against the Union institutions and bodies in the General Court is enormous. That explains that we now have this reform whereby the General Court will really be that, general, We left aside the specialized court system simply because the member states could not agree how to man them. It's a pity to find that, but that's just realpolitik. That's what it is. So we said, let's all of them have 2 judges in the General Court. They will do all the cases, in that sense, General Court, brought for judicial review against institutions and bodies of the Union. So there they will have lots of work, also in very novel in fields of union law, such as banking union, the Eurozone cases, the sanctions cases, competition, state aid, structural funds, access to documents, everything. Because even the wildest imagination cannot caption all the reality and the diversity of the reality of cases where judicial review is being sought against decisions of institutions and bodies of the Union. Now, the regulation which has adopted the reform, you should really take a look at it. It's a regulation of December 2015. It decides in Article 3, that's the provision, that the Court of Justice must re-examine the possibility of transferring to the General Court references for preliminary rulings in specific subject matters, which is already made possible, by the way, since the Nice Treaty. I was still a judge in the General Court. Now it's a legislative obligation for the Court of Justice, or of course together with the General Court, to study that possibility, and there is a precise date. We must be ready by December 2017. And the article says, if need be, accompanied with legislative proposals, because you know there it's the Court of Justice having the right of initiative. So in the year 2017, this will be a very welcome atelier, discussion forum inside the court to reshuffle competences between the 2 courts, because it may well be that the General Court now has excess capacity of judging, because by the time 2019 there will be 2 per member states, whereas we, in the upper court, we are clearly overburdened in the sense that with the area of freedom, security and justice, our numbers of incoming cases are increasing rapidly and in totally novel fields. Think about the asylum and refugee crisis, which has given rise to tens and tens and tens of preliminary rulings only since last summer, which were not, of course, would not have been there if the crisis had not been there. So we need to have some flexibility in our management, and that will be studied in the coming year.
I think we have to come to an end. But I want to ask you both the following question. Whenever I listen to President Lenaerts, I say, it's working so well. But there's nothing that is so good that cannot be better. What would you like your legacy to be when you finish your presidency? What would you like the single most important thing to be that you will be remembered for when you finish your presidency? So you come and you say, I know the court for years now, but there's one thing I would really like to do that needs to be done. And the same thing to you, President Raimondi. What would you, if you are successful, would like your legacy to be when you leave the court?
The one single thing I want to do is to increase the drafting quality of the Grand Chamber judgments of our court, even given the existing framework of collegiate decision-making. I have great ambitions in that respect. I know it can be done. In the earlier period, I quote judgments from a text of Joseph Weiler, Bidart, Bressol and Chavereau, judgments which he is praising for their drafting quality. I know these judgments very well. I don't say more. I want all the judgments of the Grand Chamber decided during my presidency to have that drafting quality. And this without any lengthening of time for decision making, because I think the present temporal framework needs to be maintained, but I shall be very creative to reorder the burden between the Court of Justice and the General Court. I belong to both, don't forget that. As an ancien to the General Court, as a present one to the Court of Justice, that is a historical chance to make the reform in depth, which ultimately should free the time and the minds to come to high quality, well-explained reasonings in all of the Grand Chamber judgments of our court, which then set the tone and the standard for all the chambers of 5, chambers of 3, and especially for the national courts complying with our judgments as part of the law of the land in their domestic legal orders. Thank you.
Thank you. No, my goals, my objectives are not very high level. They are terre à terre, in the sense that I have basically two. First, I very much would like to improve, to reduce the time which is now required to obtain a judgment of the Grand Chamber of my court. Now, on average, it takes 1 year. In some instances, it takes more. This is not acceptable in my view. So that's really too long. We were able, in one case, which was the Lambert case, Lambert versus France, a very delicate, sensitive case and emotional case concerning an end of life question. We were able in that case to produce the judgment in 6 months after hearing. So I hope that we will be able to do so for all cases which come to the Grand Chamber. And the second one is very much linked to what we were addressing before, so the problem of the caseload. So I would avoid, but I don't know whether this will be possible, when opening, at the end of my term, when we open our UDOC page, you know, our system for electronic research, that we no longer see judgments which are published on a day-by-day basis, which reflect applications filed 7, 8, 9 years before. This unfortunately happens today, and I hope this will no longer happen in the forthcoming years. Thank you.
Can I ask all of you, please, to join us in thanking Presidents Raimondi and Lenaerts for their willingness to be so open with us, to engage in conversation here, to share their thoughts. Unfortunately, I didn't get to ask my pet question about gender in the courts, but I'll just mention it, so to put the thought into your heads for the future. But we're going to, at this stage, we're going to have a short award ceremony and then close the occasion of the conference. But before we have the award ceremony, can we please give a round of applause to the two presidents?
I join in thank you the two judges. I'm one of those who think that actually judges do pay attention to what academics write. And we had some evidence of that today. It's always, we award now the prize given by the Board of Editors and the Scientific Advisory Board of I.CON for the most outstanding article published last year in volume 13. And unanimous decision. People put in proposals, but then, as Lenaerts explained, we try and reach some kind of consensus. And we're very proud to give the prize this year to Professor Kristen Stilt for her article, Contextualizing Constitutional Islam, the Malayan Experience. And I would like to invite her for me to hand her the certificate and the prize. And since she's a mother of children, this is the prize. Thank you very much. I want to use also the occasion, more briefly than last year, to give you the state of play of I.CON, which is intimately connected with I.CON S. So the statistics that interest us most in terms of what we consider the health of the journal are the number of unsolicited submissions. In other words, people who are not being invited to a symposium or for commissioned paper, but are just what the mail brings us. And I think a journal reaches a state of health when it is able to put 4 quality issues a year just based on unsolicited submissions. We don't do that by design, because we don't like to think of ourselves as a refereeing service. We like to curate the journal, and therefore we also commission symposium. We like to impose an agenda, but we like to feel that if we needed to, we would have sufficient quality in. And over the last 2 years, the number of unsolicited submissions more than doubled. And we're now in a healthy state where we do have enough articles that we could sustain the journal at the high quality it is without commissioning papers. The second stat, which to me is more important than citations, is the number of downloads of PDF files. We are suspicious of citations from a position of strength. I.CON is way up there. But it worries us because if editors are worried too much about citations, it will shape their editorial decisions. They will tend to take articles from established scholars. And at I.CON we are very proud, and the proof of the pudding is in the printing, that we really encourage young scholars that have not yet made a name. And publishing in I.CON is a way of doing that. It also, if you pay too much attention to citations, it discourages publishing esoteric topics, because esoteric topics might be very interesting, but by their nature, they're going to be read less and cited less. So the stat that we think is telling is the number of people who actually take, also not visits to the website, because we've measured those. They're millions, but it could be bot machines, or it could be people who stay 15 seconds. So somebody who actually takes the trouble to download a PDF file of a full article, we think that's significant. We're not sure they will read it, because I remember the days when we used to photocopy an article and then put it under our pillow and sleep on it, hoping something will come in. But still, if you're downloading, at least you had the intention to read it. And our numbers have doubled over the last year. In 2015, we had 128,000 downloads of individual articles in I.CON, which is a huge number by the standards of even a successful publisher as Oxford University Press, which is a kind of invitation. If you publish in I.CON, there's a chance that you will at least be downloaded, if not read. So I will leave it at that and invite Gráinne to close the entire I.CON S conference. Thank you.
So we've come to the end of this 3-day event, and I have to say on behalf of myself and Ran Herschel, my co-president, that From our point of view, it's been a really terrific intellectual event, and we want to thank many people who've contributed to making it possible. It's been a wonderfully energetic and vibrant event in this beautiful city of Berlin and the wonderful institution of Humboldt University. And we're very grateful to all of those who've made possible the success of the event. So starting with the team here, who we mentioned at the outset, but who can never be mentioned enough, Matthias Kumm, Fred Zumwalt, and their team. I urge you to look at the back page of your brochure for those people who comprised the actual operational team who did all the work leading up to and during these last 3 days to make everything work so smoothly and enhance the quality of the event. I want to also thank our organising committee and especially Lorenzo Cassini, the executive committee members who helped to put the programme together, our founding presidents, Sabino Cassesi and Joseph Weiler, to the plenary panellists and keynote speakers who gave the intellectual framing to our event, and to all of you, especially to all of those who participated, to all the panelists, for all of the intellectual energy and creativity that you bring, for asking the critical questions, addressing the big issues of the day. As Joseph Weiler said, it's not just, I think, that I.CON has doubled in numbers. We're proud of that and we're very happy to see the society flourishing. But it's particularly the quality of the society. Many people have commented with no negative or adverse judgment on those of us who are somewhat older, but it's a very young and youthful membership, and we're delighted to see that there's so much, you are the future of the society of public law. The idea of the society was to break down, or at least to begin to break down some of the barriers between constitutional law as administrative law, international law, between disciplines, political science, sociology and law and others. And I think the quality and range of the panels and the discussions that we've had over the past few days are really a testament to that. So we're, from our perspective, very pleased, and we hope you've enjoyed it just as much. We will hope to soon announce, I'll sort of pre-announce it here, but we hope soon to announce that the next conference will be held, we anticipate in Copenhagen next year around this time, hosted by I.CON, and we'll be sending out information about that soon. But we very much hope to see all of you and more there this time next year. In the meantime, thank you once again to all of you for your participation.